when this data was requested by the defense and when the Commonwealth agreed to the request, it was in a spirit of fairness because the Commonwealth expert had received the raw data from defense testing, and so clearly the Commonwealth was not going to object to Dr. Dudley or whoever the defense selected receiving the raw data from Dr. Hebben and Dr. Casey. Certainly the Commonwealth had no understanding that it would then be turned over to counsel for purposes of cross-examination. And the additional issue that Dr. Hebben has now raised is that she is very concerned, although she will obviously do whatever the court orders her to do, but this testing is proprietary. This testing is valid because the questions are not known to the subjects ahead of time. And if what Ms. Regan proposes to do is read the questions into the record, and then presumably the defendant's responses, which raises a different issue, she is very concerned that that will put on the record the questions for these tests and raise the possibility of invalidating them. As I indicated, she will obviously respectfully do whatever the court orders her to do, but this is an issue that obviously goes beyond my complete understanding, and I'd be happy to have you hear from Dr. Hebben, but it was not an issue I could anticipate because we didn't, in fact, receive the raw data.
Okay. Ms. Regan?
I assume the Commonwealth had the raw data because these are their witnesses. The reports were exchanged. They had reports talking about the data. The defense filed nothing to keep this raw data from tests performed by their experts secret. The raw data was there. I received it in an email to me, not from the Commonwealth experts, but I received it in an email to me, and of course I looked at it, and of course it forms the basis of my cross-examination. The Commonwealth is relying on these tests. I'm allowed to explore it. I haven't kept anything from anyone. This is stuff produced by the Commonwealth's own experts.
Okay. Well, the first thing is, and I don't have handwrite right in front of me this moment, but the first thing is that when raw data is requested by a Commonwealth expert, or raw data goes to a defendant's expert, the raw data doesn't go to the Commonwealth. That's the whole protection that is central to the whole same records rule procedure of handwriting. I'm not going to get into a long discussion about it because of the limitations of time, and I didn't come out here prepared to address it. But in its most stark, simple terms, it's not fair for the Commonwealth's expert not to have the same records as the defendant's expert, but that doesn't mean that the prosecutor can have it. There has to be a procedure before the prosecutor can have it. So that's number one. Number two is we are stuck right now in a catch-22. That's what it is. It's a catch-22 because the defendant is saying that this raw data is necessary to cross-examine. That means it's going to include statements of the defendant. Now, whenever that happens, you always need to duck on redirect, but that's for the defendant to decide, not the court, whether the defendant's going to open up statements of the defendant on cross-examination. But if the statements of the defendant are going to come out and the concern of the Commonwealth is they couldn't prepare for cross-examination, that I have a solution for. It's not a good one, it's a terrible one, but I have a solution for it, which is that they have the time they need to prepare. Now, it's a bad solution, which means that two things can happen. And one of them I'm not going to do over the Commonwealth's objection, which is that Dr. Crenshaw comes in out of order, which makes the testimony convoluted, and I certainly am not going to do that over the Commonwealth's objection. The second option is, well, that's the second option. The first issue is that the Commonwealth can have the time that it wants to review, and with all the unfortunate implications of that for jury time, but the most important thing here, as precious as jury time is a fair trial. The second option, as I said, which I'm not going to in any way, even if Mass Evidence Guide 611A allowed it, require witnesses be taken out of order. And the third problem is that if the Commonwealth, despite not having enough time with the raw data, wants to, for whatever reason it might be, concern for jury time, putting in the case with narrative richness and continuity, or whatever time it might be, reason it might be, it wants to go forward with its hands tied behind its back, then that solves that problem, but doesn't eliminate the third problem, which is this requires the Commonwealth to have seen this so they could file a motion to impound and that the court could consider how to deal with the cross-examination that would be exposing on television and to the world raw data that will compromise the mental health treatment of hundreds of thousands of people. So if we can get through obstacle one, and obstacle two, we still have obstacle three that the court is forced to deal with, not with a decision that satisfies Commonwealth versus Cohen as it relates to closed courtroom issues, but with a decision in the posture that we're in right now. So that's where we are. So as it relates to the issues of cross-examination, what type of questions, without getting into the... Well, first of all, let me start with the Commonwealth. Is the Commonwealth requesting to recess for the day or not?
No.
So what type of questions would you be asking on cross-examination as it relates to concerns about compromising serious issues concerning testing that's used, the MFAS test, the Sears test, and other tests that have been used as you get into the raw data?
With the MFAS, I intend to offer into evidence the interview booklet and to question about the defendant's answers. It can be marked for identification.
I would ask that it not be. My understanding is whoever gave it to them shouldn't have even given it to them. It's so proprietary.
Well, that happened nonetheless.
So
Okay.
I'm asking that it not be marked for ID at least by
Yeah,
exacerbating the
no.
problem.
Okay, yeah, all right, yes.
And then as far as the Sears goes, there are some questions that I intend to ask about.
All right, well, I need to know the implications of the questions. I need to know what the questions are in order to make incredibly delicate decisions relative to cross-examination, not by taking the 6 months or so that the Supreme Judicial Court would have to analyze it, but with the jury in the other room and two experts waiting as well. So what's the nature, I guess what I need to do is have the nature of the cross-examination so that I can do an analysis of this.
Well, on the MFAS, the expert based her decision on scores on something called reported observed symptoms. And that is actually, there's only 3 questions for reported observed symptoms on this test. And the questions, as I would assert, show that they are not very revealing, and to some extent they are silly, and it undercuts her credibility. As to extreme symptoms, I would ask about the 1, 2, 3, 4 questions that he answered and what they were, what the extreme symptoms were. As to unusual hallucinations, I would go through all 5 questions and show show which ones he answered yes to, and I would also bring out what psychiatric symptoms he denied having on the MFAS. I would also bring out, there's a trick in the MFAS. In the beginning, the test giver says, do you have ringing in your ears? And if the person says yes, they say, well, you know, sometimes people with severe mental illness have ringing in their ears during this test. And at the end, the test giver says, did you have ringing in your ears during the test? And then they use that against the defendant as being...
Let me ask you this question, Ms. Regan. As it relates to the cross-examination, and this would require a colloquy with the defendant, as it relates to the cross-examination, are you willing to waive the defendant's Sixth Amendment right to a open courtroom?
Yes.
Okay. All right, I need to make partial closure findings as to the First Amendment issues, but I need a proffer from the doctor first to be able to have those grounds. So why don't we call her in, if we could, please. Yes. What I'm doing, I hope, is clear. This is a box that, until I thought of that, this very moment had no solution. Having thought of it this very moment, I guess I can figure a way out of the catch-22 without the 6 months that the appellate courts would have to analyze it. So why don't you speak to her, tell her why I'm asking questions, and I will come back out in a couple of minutes and see if I can make First Amendment findings or not. All right, court will be in recess.
Session, you may be seated.
All right, did you have a chance to talk to the doctor? All right, and why don't we have her take the witness stand then, please? Okay. Ms. McDougall, why don't you ask the questions relative to the concerns about dissemination, if you could, please?
Let me just clarify before I ask which tests Ms. Regan intends to ask about, so I can focus on those.
Sure.
The MFAST and the Sears. Now, I have to hear the direct before I know for sure, but right now it's my intention to question on the specific questions on these tests.
Go ahead, yes.
Dr. Heben, with respect to the MFAST, are there any terms or contracts under which you receive the MFAST to be able to administer it?
When we are able to purchase these materials, we do this by demonstrating our credentials, that we've had adequate training in the administration, scoring, and interpretation of tests. So we have to attest to the fact that we have PhDs in a relevant area of psychology before we can purchase the test materials. And in doing so, there is a contract in which we agree not to disclose the test information to people not qualified to use those tests.
And certainly the publisher or the owner of the test understands there may be limited circumstances under which you do have to disclose them. Do they request certain terms for those disclosures?
They do.
And what are those terms generally?
Generally, that any kind of individual test item is not released to the general public, is not recorded in any way. The reason being is that if this information gets out into the general public, it can serve to invalidate the test for any future use, because understandably, people then might take that information outside of the courtroom and instruct individuals on how to take the test. It would be basically like releasing the LSAT questions or something like that, which would invalidate the test and require new development of new tests, which is, of course, a very expensive process.
And Doctor, to the extent you include information regarding testing in your report to experts or report to the court, you understand those reports to be submitted under protective orders. Is that correct?
In my report?
Yes.
Correct, but I don't put test questions in my reports.
And is that the crux of the problem, the actual text questions appearing in public or in the report or somewhere someone could access them?
Correct.
And is what you've described with respecting to the MFAST, is that also true of the Sears?
Correct.
So essentially for any of these tests it would be true, is that correct?
Correct. We are required, both by our ethical principles and by intellectual property law, to not disclose the particular test items.
And disclosing them would be a violation of your contract absent specific court order, is that correct?
Correct.
Disclosing them would be a violation of the copyright of the publishers, is that correct?
Yes.
And disclosing them would present an ethical problem for you, is that correct?
Correct.
And can you describe the ethical problem for you?
Well, in our ethics, in the ethical principles of psychologists, our code of conduct, there is a whole section, I think it's the standard sections 9 and so on, that discusses when, for example, raw test data can be released and when test materials can be released. The former, raw test data, can be released under certain stipulations. The latter, test materials, cannot be released. So we're not allowed to provide, for example, test manuals to attorneys or to people who are not allowed, who could not purchase those materials on their own from the test publishing company because they don't have the credentials.
And I think you've articulated this, but if you could, let me ask you this. With respect to the MFAST and the Sears in particular in this case, both of those tests are tests of potentially a malingering, is that correct?
Those are tests that are specifically designed to assess for the presence of malingering.
So having someone who's being tested have access to those test questions ahead of time could greatly damage the testing of those people.
That's correct. I mean, we've actually seen that for some tests that have been released. If you were to Google a particular test,
Well,
and
that's what we're doing right now, actually. As you speak, I've got the clerk Googling to see what we can get and what we can't get.
no, but what I'm saying is that some tests have been compromised because information has appeared in the media, and so we actually anticipate that we can't use particular tests because they're no longer valid for the purposes of which they were developed. I'm thinking in particular of the test of memory malingering, which we really have to be careful about.
So, we're looking, I asked the clerk to look up whether you can get these MFAST questions and Sears questions on the internet, or whether you can just go on and buy it. So I guess the first question is, can you go, as the clerk's trying to do right now, can you just go on the internet and get these questions?
You should not be able to unless someone has illegally put them up there. Very often when, like if we're Googling something, looking for information, and you stumble upon someone who has disclosed information, typically you contact the test publishing company and they'll get it taken down. I don't think you're going to be able to find the Sears and the MFAST questions on the internet. You certainly find scientific studies related to them.
Mm-hmm. Okay.
And if I could just approach the witness, Your Honor?
Sure.
Well, in the break, you went on the Pearson website, is that correct?
That's correct.
And is Pearson the publisher of one or both of the tests we're discussing?
I'm not certain. They're just representative of the attitude of the legal policies of the various companies.
So the legal policy described in that document would be consistent in your experience with the legal policies of all the publishers of these tests?
Correct.
I'd ask this be marked for ID, Your Honor. And Doctor, in addition to the other issues you've described, does the legal policy and your own understanding of your ethical obligations recommend you make a call to the American Psychological Association when these issues arise?
To some sort of ethics organization that, or ethics department committee to help us figure out how to deal with these kinds of issues.
And have you and Dr. Kinshirf been endeavoring to do that during the time we've had this morning?
Yes, we've been unsuccessful at this point in directly contacting anyone. There's an email out at this point. His phone calls didn't work, but I don't believe we had a response yet.
If I could just have one moment, Your Honor.
Sure.
I have nothing else for this witness for this.
Anything on this issue, Ms. Woody? All right. How about, you mentioned that these tests are used in a lot of situations. Like, for instance, what happens from your experience in a sexually dangerous person case, or well, care and protection wouldn't be a good example because that's a closed courtroom, when there's examination about raw data, or have you not been in that situation?
I have not been in that situation.
All right. All right. Well, this is my thought. I don't see, you can step down, Doctor. I may have some questions. Actually, maybe you should stay there in case I need some follow-up questions. Here's my thought. There's no reason to close the courtroom. The court does not need a reason for there not to be any audio or video of a witness. There's no right to it, so I don't need any reasons for it. So the only thing that's left is the print media, and I'm thinking out loud here. I think what I could do is just leave the courtroom open and have any members of the print media come inside and tell them they're under an order not to write concerning the questions that are part of these tests and the answers that are part of these tests in any news story or in any other way, and that requires, since it's a prior restraint, a serious reason. very serious reason. I credit the testimony of the witness, and the serious reason that's been articulated is that two of the, and this is why I'm glad I had you stay on this stand, Doctor, two of the most important tests that are utilized for the purposes of testing malingering would be compromised for mental health providers throughout the country were the court to not order otherwise.
Correct.
Is that a fair statement?
That is a fair statement.
All right, well, if that's not grounds for a prior restraint, I don't know what is. All right, so what I'm going to do is have court officers, Mr. Lang, just make sure any member of the press who comes in that we're alerted to it, that's not already here. And if I could just ask any print media, the order relative to the cameras doesn't start, not being able to film doesn't start until you get to specific questions. Is that going to be your first area of inquiry?
No.
All right, so when that point comes, you'll let me know. All right, if I could just Your Honor,
to make clear that not only can the print media not report on it, but that the audio and digital media can't report on it. Just because they don't have film of it doesn't mean, as we learned when they were down, they won't say it.
No. You know what? I thought that was explicit, but you're right, it's implicit in the order. All right, the court finds that that the testimony of the witness during the voir dire is credible, and that she believes that release of this raw data and answers would jeopardize mental health professionals' ability to treat for malingering would be jeopardized. Is that a fair statement?
That's a fair statement.
Okay. All right. Do you want to be heard further?
Just one little item on behalf of Dr. Heben, just to cover her on the ethical front, if the court could directly order her to testify to it.
I will. I will when we
In the nicest way possible,
get to that
understanding.
point.
She's not saying she won't, but just for her ethical.
Yeah, I will. What I'm going to do is, because I think it's only fair, is that there's a problem here. So it's 12:09. We're going to go as far as we can on cross before I issue the order in case a lawyer wants to come in here and file something before we get to the issue. So
Still have a decent amount of direct as well.
good. All right, so that takes care of the issue of allowing time for lawyers to come in and seek to intervene as it relates to the prior restraint. All right. Caitlin, can you talk to the reporter who's raising her hand outside the courtroom? Yes. Okay. All right. So we have testimony that we still need to do, so let's bring the jury in, and then we will continue. All right, court will be in a short
All
recess.
rise.